All right, if you're gearing up for the Queensland bar exam, you know that expert evidence can be a real minefield. So welcome to our explainer on the UCPR's rules for taming that infamous battle of the experts. We've all seen it, right? You get these dueling experts, their reports completely contradict each other, and suddenly the legal costs are just spiraling. It's a mess that can actually hide the truth instead of finding it. But don't worry, the UCPR has a very specific framework designed to bring some order to all that chaos. So, here's our plan. We're going to look at the framework for taming the expert battle. Then we'll walk through the two main pathways for appointing a single expert, either jointly or by the court. And we'll wrap up with the really important stuff, the key strategic takeaways for you as counsel. The solution you're looking for is right there in Division 5 of Part 5 of the UCPR. I want you to think of this as your procedural toolkit. It's specifically designed to take expert evidence out of that adversarial head-to-head contest and turn it into a process that's way more objective and efficient, and it gives us two clear routes to make that happen. Okay, first up is the joint appointment pathway. Now, this is all governed by rules 429L through to 429Q. This is the path you take when the parties themselves decide to get on the same page and agree to appoint a single shared expert. It's all about taking control of the process. This is your roadmap for the entire joint appointment process. It's broken down into 5 absolutely critical steps under the rules. For your exam, you really need to get this sequence down cold, from that initial appointment right through to the legal consequences, which we're about to get into. Everything kicks off with the gateway provision, Rule 429L. The key things to lock in your memory here are you need 2 or more parties, the agreement has to be in writing, and it's for a report on a specific issue. It's a simple start, but it's the foundation for everything else. Now think of Rule 429M as your non-negotiable checklist. This rule lays out the mandatory bits for a valid appointment. You have to agree in writing on the issue, who the expert is, the deadline, and who's paying. And crucially, the expert has to consent, and you've got to serve that agreement on all the other parties. If you miss a single step on a Rule 429M, the whole appointment could be invalid. It's that serious. So this brings up a really common practical problem. What facts does the expert actually use? Well, Rule 429N gives you a fork in the road. Sub-Rule 1 is the dream scenario. You give the expert a single, agreed statement of facts. Perfect. But if you can't agree, Sub-Rule 2 lets each party provide their own version. This is a classic exam question, so make sure you know both sub-rules of 429N inside and out. Once the report is written, Rule 429O tells you exactly how to disclose it. And it's a formal 2-step process. First, the report is given to the parties who appointed the expert. As soon as that happens, a 14-day clock starts ticking. They have exactly 2 weeks from that moment to get a copy to every other party in the case. And this leads us to the consequences, which are really 2 sides of the same coin. Rule 429P is powerful. It says that this joint expert is now the only expert who can give evidence on that issue. Big deal. But Rule 429Q protects a fundamental right. Every single party can still cross-examine that expert. And notice the crucial get-out clause in both rules, unless the court orders otherwise. Never forget that. But what happens if the parties just can't agree? Or what if the court itself decides it needs to step in? Well, that brings us to our second pathway, a court appointment, which is all covered by Rules 429R to 429U. The heart of this pathway is Rule 429R. It gives the court this really broad power to just appoint an expert at any point in the proceeding. They can do it on their own initiative, or a party can apply for it. And just like a joint appointment, the expert still has to consent. So, why would a court use this power? Well, case law gives us some really clear examples. Imagine a case with, say, 29 different properties. That could mean 58 different valuation experts. A total nightmare. Appointing one expert streamlines the whole thing. The court will also step in to save a ton of money or, and this is key, just to make sure it has the technical info it needs to actually deliver justice. But, and this is a huge but, this power has a critical limit, and this quote from the Gales case sums it up perfectly. The court's power is not a rescue mission for a party that just hasn't prepared their evidence properly. If your application under Rule 429R looks like you're just trying to plug holes in your own case, it's going to get rejected. The whole point is to assist the court, not to help out one of the parties. You know, timing is everything. And the big lesson from the Mishpaka case is don't jump the gun. If you apply for a court-appointed expert under Rule 429R, before it's even clear that the issue needs to be decided, the court will probably just say no. You're being premature. You have to wait until that expert's input is clearly and necessarily required. Now, the journey of a court-appointed expert's report is totally different, and it's all laid out in Rule 429S. The expert doesn't send their report to the parties. Nope. They deliver it straight to the court registrar. The registrar files it, seals it up, and then sends it out. This whole process is designed to keep the expert completely independent from the parties.
So right after that process, Rule 429T officially defines disclosure as the moment the registrar sends out the report. Then you've got Rule 429U, which is basically the court's ultimate power tool. It gives the judge this incredibly wide discretion to make any order they think is needed, everything from deciding who pays the expert's bill to exactly how that report gets received into evidence.
Okay, so we've looked at both the joint and the court-appointed pathways. Now let's put it all together. Let's talk strategy. How do you, as counsel, decide which of these tools you should actually use and when? First thing, never forget the unifying rule, Rule 429V. This is such a vital provision because it makes it clear that any expert appointed under Division 5, doesn't matter if it's by the parties or by the court, can go straight to the judge and ask for directions if they get stuck. It's like a built-in safety valve for the whole process. So what's the big strategic advantage of using these rules, especially getting a court appointment under 429R? Well, having a single objective report can just cut through all the noise and lead to a much earlier settlement. The savings in time and money can be absolutely enormous. And, maybe just as importantly, it gives the court a handle on what can sometimes be a runaway expert fee budget. But, and there's always a but, there is a significant trade-off. There's a downside to all those pros we just talked about, and this quote from the Fricker case just nails it. When you have a single expert, you lose that close working relationship. You can't just pick up the phone for some ready assistance or to bounce theories off them in the same way you could with an expert that you've retained just for your side. So the ultimate takeaway here is this. Division 5 gives you some really powerful tools, but they are not a one-size-fits-all solution. Your job, as counsel, is to look at the specific needs of your case. So the final question you have to ask yourself every single time is, which path, joint appointment or court appointment, is truly going to best serve my client? The efficiency of one expert or the strategic edge of having your own?